And just a quick intro on the Legacy Business Program. Um, so, small businesses have always been known as the backbone of our city. And then to ensure that these businesses stay around, Council launched the Legacy Business Program last year. Oh, and doesn't want to. So, the definition of a legacy business is someone that's been a business that's been around for at least 20 years within their same community. They have to meet three of the following four criteria: contribute significantly to its community's history identity, sustain or cultivates cultural traditions or practices. The business can't be franchised and it has to provide goods and services in a language or manner that is culturally accessible to their community. Our current state of the program, we have 710 legacy businesses enrolled in the program. So if you feel like you met the prior criteria, definitely fill out the application and apply to be part of it. Some of the highlights of the program is we offer promotional activities. They'll be featured on our website as well as our social medias. We signed a promotional toolkit to highlight yourself as a legacy business, such as the sticker in the picture. And hopefully this will lead to increased visibility and exposure to potential customers. We also have our own exclusive grant for legacy businesses. It's up to 20,000 depending on how many employees you have. Round 2 just closed, so round 3 will be opening next year, probably like late summer. And then part of this webinar series is the toolkit. You can access them all at our website, and that website link is right here. So we'll be here, and let us know. Reach out if you have any questions.
Before I introduce the speakers, I wanted to launch, we're going to have a couple poll questions during the webinar. And our first one is, what decade was your business established? So if you can let us know by clicking on the decade that your business was established, we'll share out those results in just a second. Thank you for participating. Okay, I think we'll just give it a little bit more time. I think we could close the poll and share the results. Okay, so most of the attendees today's business started in the 1940s to 1959. Amazing. And congratulations for all of you for continuing to operate and thrive. So I'm going to introduce our speakers today. I'm very excited to welcome Ramia Sinha. She's an Equal Justice Works Legal Fellow on the Small Business Development Team at Tzedek. Her work focuses on supporting legacy businesses across Los Angeles to prevent displacement and advance generational wealth building and economic justice. She graduated from Chapman University in 2022 with a BS in Business Administration and earned her Juris Doctorate from the University of San Francisco School of Law in 2025. Welcome, Ramia. We also have Ritu Mahajan Estes, and she is the Directing Attorney of Public Counsel's Community Development Project. Ritu led Public Counsel's efforts to provide legal services to hundreds of low-income small business owners across LA County each year. She oversaw the delivery of these services in multiple languages and has worked to ensure their services are fully accessible. In the aftermath of the pandemic, she successfully negotiated settlement agreements for business owners negatively impacted by COVID-19 that involved the waiver of thousands of dollars in rent debt and defended clients in frivolous and impermissible unlawful detainer and breach of contract lawsuits. Thank you both for joining us, and we'd like to invite Ramia to get us started.
Awesome, awesome. Thank you for that introduction. Let me go ahead and share my screen so we can get started. All right. I think, can everybody see my screen here? Okay,
Yes.
awesome. Okay, great. Well, today we are going to discuss commercial leasing. And we're not going to get too much in the weeds, but we just want to discuss some key overview, key basics. And with Tzedek and Public Counsel, we are able to help small business owners, legacy businesses with webinars, presentations, educational resources, helping with direct client representation as well, and small business academies. So these are just some things that we offer. And when it comes to direct client representation, we're able to help with a lot of different issues, such as reviewing contracts, drafting contracts, reviewing your commercial lease, IP, employment law, etc. Just want to have a quick disclaimer that the following is merely just intended to be like educational. The attorneys presenting today are not providing legal advice or entering into any type of attorney-client relationship. We just want to be able to provide you all with some great like educational guidance. So yeah. So the topics we'll be covering today. First, we'll be covering commercial leasing overview. Second, key terms to a lease. And then third, we'll be discussing a new legislation called SB 1103, which is really, really important. Okay, starting with part one. And I'll go ahead and kick it off to Ritu.
Hi, everyone. Good morning. Ramia, did we want to do the SB 1103 poll now, or should we wait?
Um, I guess we can do it maybe before we get to the part three of SB
Okay.
1103, but it's, yeah,
Okay.
whatever.
Hi, everyone. Thanks for being here today. My name is Ritu. I'm with Public Counsel. So, we talked a little bit about our small business legal aid program, and we hope that you access our services. We'll have information at the end about how to apply for our free legal services. But now we're going to be talking about some key issues that you need to be aware of when it comes to commercial leasing. Um, and I know some of you, have a brick and mortar space, some of you may not, but as those of you with commercial space know, it can be a hard sort of path when you have commercial space in terms of keeping that space, being able to afford the rent, managing conflict with your landlord, trying to figure out, whose responsibility it is to make repairs. In the course of your tenancy, a lot of illegal issues come up. And then for those of you that may be moving to a new location, there's things that you should be looking out for when you're leasing space. And so those are the things that we are going to cover today. So just, in the first instance, commercial leases are what's used for people that are renting out space to run their small businesses. That's as opposed to a residential lease, which is a lease you sign to rent out space for your home. It's recommended that your lease be in writing and signed by both the landlord and the tenant. I know some of our clients do not have written leases, they have oral leases, which, those oral agreements are enforceable too and valid. But the reason we recommend having a written lease when possible is because if there's ever a dispute or you and your landlord, disagree on something related to the property, if it's in writing, it's harder for the landlord to deny that, that is part of the agreement. It lessens misunderstandings, and it makes sure everybody understands the expectations on both sides when things are in writing. We have plenty of clients who had a lease, at one point in time, and now they're month to month, meaning their lease has ended, the term of the lease has ended, and now they've converted to a month to month tenancy. That's okay too. And usually in that situation, the terms of your lease still hold. So, even though the actual length of it is over and now you're month to month, the written lease still has the information that both the landlord and tenant need to follow. And then just really want to point out that the law does treat commercial spaces and commercial leases very differently than residential spaces and leases. Commercial tenants, unfortunately, do not have the same level of protections as residential tenants. And this is important because if you ever have a dispute with your landlord over repairs, or your landlord tries to evict you, it's a different process in terms of like any defenses that you may have. Next slide, please.
Sorry. It skipped ahead a little bit. Give
Okay,
me 1 second.
no worries.
Okay. I think this is the next slide.
Okay, so when looking for commercial space, you need to think about a few things, such as what location do you want to be looking at, what's your price point, how much space do you need. It's always recommended to consult like a real estate broker if you can access one, an attorney to review any leases. Think about insurance that you may need to have. A lot of commercial leases will have requirements for insurance, like you may have to have a certain level of insurance and certain types of insurance. So it's important to have certain professionals, on your side helping you in this process. Both Public Counsel and Tzedek do help small business owners to negotiate leases and review leases and even draft leases. So please contact us if you need help. Sorry, Ramia, could you go back real quick to the other slide? Okay. And then if you do find a space that you're interested in, you sometimes will submit like a letter of intent where you say, that both sides might have something in writing about we want to intend to lease this space at a certain rate. That's not a lease. It's just sort of like a precursor to a lease. And then you'd want to actually, negotiate and enter into a lease. Next slide, please. Okay, sorry about that. So in the letter of intent, which is not a binding agreement, if you do end up having a letter of intent before your lease, it's going to include certain basic terms, which I kind of mentioned. So what's the rent going to be? How long is the lease going to be for? What is the size and address of the premises? Are you renting the premises as is, which means like the landlord's not going to make any changes to it and repair it. It's just kind of like it's up to you as a tenant to assume responsibility for the space and be okay with it as it is. The letter of intent may include information on whether you're going to be spending money on building it out and making it improving it, and whether the landlord's going to give you like any credit for that, or like a rent reduction or waiver on rent. And it could include, whether it's like a 2-year lease with an option to renew for another 2 years. It may include information about the security deposit as well. Next slide. Okay. So next slide, please.
Ritu, did you want to talk about this tenant entity, or you want me to keep going?
Yeah, you can keep going. I'll mention
Okay.
it in the next slide.
Gotcha.
So we're going to be talking about the key terms to a lease, which also include, who is signing the lease on behalf of you, the tenant, right? So in an ideal world, if you have a business entity such as an LLC or a corporation, you'd want the lease to be between your business entity and the landlord. Because then, if something goes wrong and the landlord accuses you of breaking the lease or leaving before your lease ends, then the party they would hold responsible is the business entity, which we think is better than, them holding you personally responsible, because then if they can only hold the business entity responsible, they can't come after your personal assets, for example. The problem is many times landlords don't want to just enter into the lease with your business entity. They will want you to either sign the lease in your own name, or they will want you as the owner of the business to give a personal guarantee. And, obviously we recommend you try to negotiate with the landlord to not have to do that. But it's tough. And I do know a lot of times landlords will require it. And giving a personal guarantee, what that means is like, if something goes wrong and the landlord says you broke the lease or your business broke the lease, then the landlord can come after you personally, whether it's for, money damages or some other, legal remedy. So there are a lot of basic terms in a lease, like how long it's going to last, whether you're going to have any options to renew, whether you have the right to assign it, meaning like if you need to sell your business, are you going to be able to, assign the lease to this new party that you've sold it to? Are you going to be able to lease out a little part of the space to someone else? That's called subleasing. It'll have, information about rent, whether you're allowed to make any improvements, and if you have to get landlord permission to do that. It'll have information whose responsibility to make repairs, information about security deposit, what happens if someone breaks the lease, and then what happens if someone keeps staying at the property beyond when their lease ends. And when you're looking at all these terms, you have to think about, okay, what are my what am I willing to agree to and not agree to? And is there anything in the lease that would force me to walk away if I can't get the landlord to negotiate with me? Next slide, please. Okay. So, the term, right, it might be 1 year, 3 years, 5 years, but it'll specifically include like when the lease takes effect, and also, when the rent kicks in, right? So what's the first day of rent? Some leases will, be signed on December 1st, but say that rent's not due till the following January, for example, because maybe the tenant needs to make certain improvements or they won't have the ability to move in right away. So it's important to look at, the term and when the lease starts and when the rent starts to be due. Also, again, as we mentioned before, does it give you the right to renew it, when the initial lease ends? Next slide, please. Yeah. And so assignment and subletting is super important. I've had so many clients who, because of COVID or other economic issues, they're not able to keep their business going, but they don't want to lose their entire investment and everything we work so hard for. So they want to be able to sell their business and have the new business owner take over as tenant. And the thing is, your lease may have restrictions on that, right? So you can't just assume if you sell your business, then your landlord will just be okay with it. You have to look at your lease. What does it say? Does it give you the right to sell your business and have the landlord, work with the new tenant? Does it say that the landlord has to approve the new tenant? Usually assignment and subletting provisions and leases will say, whether or not it's allowed. And it'll often say if it is allowed, it's only with landlord permission. So that's something to look at. I think, in a perfect world, if you're trying to sell your business, what I like to do for clients is have them find a buyer, have the landlord screen the buyer and say, okay, I'm willing to take this person on as a tenant. And then have the landlord agree to end your lease so that you're out of the picture and sign a new lease with this buyer. Because if you're still involved, like if you do an assignment, it's possible that you might still be on the hook if rent doesn't get paid by the new tenant. So it's just important to do these things properly and think through how to do it. And if you need legal help, if this is something you're concerned about, or you want to sell your business, you can please reach out to Public Counsel and Tzedek and we can guide you through it. Okay, next slide, please. Okay, I think someone asked this question in the chat. So there are different types of leases, right? There's a lease that we call it's like a gross lease. Basically, it just says, the tenant has to pay $2,000 a month and that's it, right? That's just the rent and no other bills does the tenant have to pay. And it's just like a flat amount. Then there's also this other type of lease called percentage rent. I don't see these often, but basically your rent is based on a percentage of your revenues, in addition to a fixed amount of rent every month. So maybe your base rent is $2,000 plus you're going to pay an additional amount every month, based on the percentage of your revenues. Again, I don't see this type of lease very much. Then we have the net lease, which is it's often referred to as the NNN. Um, or it's, yeah, basically this is the type of lease that includes you pay a base rent, plus you're going to pay extra for the landlord's operating costs for like maintaining the whole property. So, that might cover the landlord's cost to hire security or landscaping or to pay for taxes or insurance. Usually in these kind of leases, it'll say your base rent, and it'll say you're going to pay 15%, for example, or whatever certain percentage of the landlord's total operating costs. And the percentage is based usually on the square footage of your place that you're renting. So if the place you're renting is super small, then the percentage would likely be very small, right? This is an area where we had a lot of clients call and say, my the amount I was paying, the percentage keeps changing. Like, I was paying an additional 500 every month for the landlord's operating costs. Then all of a sudden now they're saying I need to pay 1,000, or they're saying at the end of the year that I owe them all this money for the operating costs. So it was coming up a lot where tenants were facing this problem. And so we'll talk about it later, but SB 1103 has some language in it that addresses this issue. But essentially, this is something you really need to be careful about in your lease. If you're signing a new lease, what does it say about what you're on the hook for when it comes to the landlord's operating expenses, which are also called common area maintenance fees, CAM? Next slide, please. Okay, so this is also very important. So when it comes to repairs, which of course, over the course of your tenancy, things are going to fall apart. We've had so many clients that because of the rains in LA and the properties are old, the roof caves in, there's flooding, the ceiling collapses. And so again, before signing a lease, or even if you have a lease now, look at the repair section, right? What does it say? Whose duty is it to repair the roof, the foundation, the inside of your property? Usually in standard commercial leases, it will say that it's the tenant's responsibility to repair things that are in the inside of the unit. And it's the landlord's responsibility to repair like the roof and the structure and the foundation. But you do need to read your lease because it's all governed by the lease. And also, there's no, for residential tenants, we have laws, right, that say that the landlord has to make sure that the place is habitable. And also, the law says that if you're a residential tenant and the place is not habitable and you've told your landlord to fix it and they haven't, you have this right to not pay your rent until they fix it. Well, for commercial tenants, we don't have those same rights. So if your landlord's not following the lease, like let's say the lease says the landlord has to fix the roof and the landlord's not fixing the roof, you can't, then tell the landlord, well, I'm not going to pay you rent. That's not something you can do for commercial leases. Because if you don't pay the rent, the landlord can give you a 3-day notice and try to evict you. Your remedy, if the landlord's not following the lease, is to potentially sue them and say, you're violating the lease and I'm going to sue you, whether it's in small claims court or regular court. Next slide, please. Okay. And if for improvements and modifications, which obviously tenants also want to do over the course of the tenancy, usually you're going to have to get the landlord's permission before doing anything. So be mindful of that. Like, don't be making improvements or changes to the property without the landlord's permission. And read your lease to see what it says about, making these kind of changes. Next slide, please.
Okay. All right. So another key term to a lease is your security deposit. So what form is the security? It can be in the form of a cash deposit or letter of credit. And a cash deposit is typically 1 to 2 months rent, and due at lease execution. And you can try to negotiate for a reduction in the security deposit during the lease term, but if any rent is overdue or if the landlord incurs any costs resulting from you not doing something required under your lease, such as making a repair that you're responsible for, your landlord can then deduct the overdue amount from your security deposit. And if the deposit is used in that way, your landlord can oftentimes require you to restore the balance of the original security security deposit. So that's something to keep in mind. And landlords, of course, take an aggressive position as far as returning the security deposit at the end of the lease. For example, they might apply the deposit towards fixing up the space instead of returning it. And the lease will probably have a provision about what condition the space needs to be in when you move out. So make sure you are reading your lease very carefully and making sure you understand the exit provisions and document the condition of your space extensively when you leave. So making sure you're taking photos, videos, potentially even bringing in a witness as well with you before you give your landlord the keys and hand it over. Okay, so personal guarantee, Ritu talked a lot about this before, and this is important because if you sign a personal guarantee, you as the individual are liable, not just your business assets. So if at all possible, you should not sign a personal guarantee, but we know that landlords oftentimes require it. So at a minimum, you really want to understand it carefully and do your best to try to negotiate limits to it, to the scope or the amounts you can be found liable for if you default. If that's possible. Again, we know that landlords oftentimes like to require tenants to sign these personal guarantees, and they may be mandatory and they may be non-negotiable. But still, it's important to understand what this means. And you really want to think about your personal assets versus your business assets. So if you sign a personal guarantee, you really want to think about what personal assets you may be putting in jeopardy if you do default on your lease. If you don't sign a personal guarantee, and let's say you have an LLC or a corporation, then you would only be liable as to your business assets and not your personal assets. So again, this is really, really important to keep in mind and make sure you understand what this means. Okay, so notice, method, and period. Um, your lease may also contain notice requirements that apply to various things, such as increasing your rent, terminating your lease, or modifying your lease, as well as like landlord entry. But again, it's important to note that there are no guaranteed notice periods under California law for commercial leases. Okay, so another key term that you might see is what's called an operating/continuous use covenant. Essentially, what this means is it just requires a business to remain open. Typically, we see these in shopping centers, malls. Usually, there might be some type of like anchor tenant, like a big department store or movie theater that draws customers to a center. So these types of continuous use covenants would likely apply to those types of businesses. But you really want to ask yourself, is this necessary for me? So if you see this type of provision in your lease, ask, well, am I a seasonal business? Am I only open for certain months of the year? Maybe only certain days of the week or etc. Because if that's the case for you, then this continuous use covenant, it wouldn't really be necessary. And also, if your landlord insists upon a continuous use covenant, at that point, you should try to at least carve out exceptions for closures for events like renovations or inventory count at the minimum. Okay, so default. Both landlords and tenants can be in default under a lease. And a default can be monetary, meaning, you failed to pay your rent, or it can be non-monetary, meaning you failed to perform an obligation that was required of you under your lease. And so make sure you understand your lease obligations very carefully. And that your lease gives you a reasonable time period to cure, or cure meaning fix the issue. And your landlord has several remedies if you do default. So they can apply the security deposit, like we just talked about. They can terminate the lease and sue for damages or eviction. They can relet the premises and collect their leasing costs and unpaid rent balance. And they can keep the lease in place and sue for full rent when due. And finally, they can also sue any named guarantors for damages as well. So please keep that in mind. And if your landlord is in default, depending on what it says in your lease, you might be able to terminate the lease for default and failure to cure, and move out and seek damages incurred as a result of having to find a new space and move out. But please, again, read your commercial lease to see if it would allow for that. And please be aware that some commercial leases have accelerated rent and or consequential damages clauses, which can be very dangerous. Accelerated rent clauses can make a large portion or the entirety of the rent become due when you're late. And you may be responsible to pay your landlord's consequential or essentially additional damages if you fail to perform an obligation under the lease. So, if at all possible, really try to avoid these accelerated rent clauses and negotiate to include a waiver of any consequential damages in your lease. Okay, so holdover and surrender. So essentially, what happens if a tenant does not vacate the premises at the end of the lease term? That triggers what is called a holdover, and the holdover provision, which typically is a lot higher amount of rent from the period that the tenant is holding over in the premise until they vacate. I just read somebody's commercial lease where the holdover provision was an increase of 50%, 50. So that was huge. It's really, really huge. So please, please be aware of this. And, if you want to renew your lease, start negotiations early. Start negotiations before your lease ends so that you don't become subject to this, holdover and inflated rent that comes with this holdover provision. Okay. So as Ritu mentioned, there's some insurances that commercial tenants are required to have, like property insurance, liability insurance. Um, and you want to, of course, ask your insurance agent to review these insurance provisions in the lease, and to regularly review the policy to ensure compliance. You also want to obtain a certificate of insurance as proof of your current coverage. And please, you don't want to allow your coverage to lapse. So make sure you're staying on top of that. And also make sure any additional insureds, usually your landlord and their lender, are also named and covered. And, like with repairs, there's often a split of insurance obligations where the tenant may insure the interior of the premises and its fixtures and property, while the landlord carries insurance on the building and the overall structure, and common areas like parking lots, sidewalks, landscape areas, shared lobby, places like that. And when the landlord carries insurance, it will usually be charged back to the tenants as additional rent. But please, it's important to note that it's really important to check with your landlord to make sure that they genuinely have the proper insurance. So you not only want to have proof of your coverage, but we also want to make sure the landlords are showing us proof of theirs as well. Okay, so this part we're going to be talking about a new law called SB 1103. And this law is really great and really important. Oh yeah, here's a little poll question for you. If you all can take just a second to answer it. The question is, are you aware that California even passed SB 1103? Okay, yeah. So most people have not heard of it. Um, and from the work that I've done so far, I feel like that's pretty common with commercial tenants that I've been speaking with, have never heard of it or maybe heard of it, but just don't know. And this law is really, really important. So I'm excited that I'm here sharing it with you all. So all right. So what is SB 1103 and who does it cover? So SB 1103, it's a new law that is effective January 1st of 2025. And so it applies to what is called qualified commercial tenants or QCTs. Um, And what that includes is one, it could be, a micro enterprises with 5 or fewer employees. And what that means, micro enterprise, you could be a sole proprietor, you could have a partnership, LLC, a corporation, any of those things, but with 5 or fewer employees. Two, you could be a restaurant with 10 or fewer employees, or three, a nonprofit organization with 20 or fewer employees. So if you fall into any of those three categories, then you are what we call a qualified commercial tenant. Um, and so SB 1103 provides protections on a few different things. One, language access, two, extended notice periods, and three, standards and transparency with respect to building operating costs, but I'll get to that in a second. Um, I just want to note that it applies to leases executed or tenancies commenced or renewed on or after January 1st, 2025, month-to-month tenancies, and also applies to leases executed or tenancies commenced before January 1st, 2025 that do not contain a provision regarding building operating costs. Okay, so how do you exercise your rights under SB 1103? Well, one, QCTs, qualified commercial tenants, must notify your landlords of your qualified status in order to receive protections from this bill. So within the previous 12 months, a tenant must have provided the landlord with one, a written notice that you are a qualified commercial tenant, and two, a self-attestation on the number of employees that you have. And unless tenancy is for a period of less than 1 month, so like a week to week, the tenant must provide the notice and self-attestation by the execution of the lease and annually thereafter, as long as the protections apply. Okay, so the first protection is language access. So SB 1103 requires a written translation of commercial leases that were negotiated in Spanish, Chinese, Tagalog, Vietnamese, or Korean. And this is regardless of whether the QCT, the tenant, negotiates the lease through their own interpreter. And so if your landlord does not follow this right here, your remedy, you may rescind a contract that violates this agreement or this requirement. Okay, so the second protection that SB 1103 provides is extended notice. So we have two different things here. So we have increased notice periods for rent increases, one, and then for termination of tenancies. So for rent increases, your landlord must give you, as the qualified commercial tenant, at least 90 days notice of a rent increase that's greater than 10%. And then they have to give you at least 30-day notice for a rent increase of 10% or less. So make sure you're keeping an eye on, how much is the percentage so that you can see like, okay, yes, it's greater than 10%. All right, then that means I get a 90-day notice. So just keeping that in mind. And for termination of tenancies, the landlord must give a qualified commercial tenant, if the qualified commercial tenant has occupied the property for less than 1 year, then the landlord must give at least 30 days notice. But if the QCT has occupied the property for 1 year or more than that, then the landlord must give at least 60-day notice. Okay. And so this goes into the building operating costs. BLCs, essentially, it's often under operating expenses or what Ritu was saying earlier, common area maintenance fees, CAM fees. But this is a little bit more specific. So BOCs are costs that are incurred on behalf of a tenant for the operation, maintenance, repair of the commercial real property, including but not limited to the maintenance of common areas, utilities that are not separately metered, and taxes or assessments charged to the landlord pursuant to property ownership. And so under SB 1103, this new law, landlords must provide QCTs with what we call supporting documentation if they intend to charge these building operating costs. And supporting documentation, what that looks like, it's a dated and itemized quote, contract, receipt, or invoice from a licensed contractor or a provider of services, with some type of like tabulation showing exactly how the costs are allocated among tenants. And also a signed and dated attestation by the landlord that the documentation and costs are true and correct. And I think this is helpful so that, they're required to just kind of show you explicitly how they're determining these costs, what these costs are, instead of just being able to just charge you whatever. And then you're kind of like left in the dark as to what these charges are. Okay, so a landlord may only charge a QCT with these building operating costs if one, the costs are allocated proportionally per tenant. So by square footage or another type of like documented reliable method. Two, the costs were incurred within the previous 18 months or are reasonably expected to be incurred within the next 12 months based on reasonable estimates. Three, the landlord provides a notice before the lease is executed, stating that the tenant may inspect the supporting documentation of these BOC costs upon written request. Four, within 30 days of a written request, the landlord will then provide you with the supporting documentation that you're able to inspect. And then five, the costs do not include expenses paid by a tenant directly to a third party. And six, the costs do not include expenses which insurance or the qualified commercial tenant or another third party already reimbursed to the landlord. Okay, so what are your remedies under SB 1103 if your landlord doesn't follow all the things we discussed? So, in the case of the language requirement we talked about, if the landlord doesn't follow that, your remedy, you are allowed to rescind the lease. And so now in regards to the failure to comply with the BOC requirements, you aren't allowed to rescind the lease at that point, but you can use this as an affirmative defense to an unlawful detainer eviction suit. So if you are sued with unlawful detainer, then essentially you're able to say, hey judge, like actually I have this affirmative defense. My landlord failed to comply with the BOC requirements under SB 1103. So that's what that would look like. And landlords who violate the BOC terms are also liable to a QCT in a civil action for one, actual damages in the court's discretion, two, reasonable attorney's fees and costs, and three, possibly punitive damages, even though that's not as likely. This is just a slide on legacy businesses, but I don't need to discuss because we've already had folks discussing it. But, I just wanted to, again, just talk about how awesome this legacy business program is and how useful that this legacy business toolkit is. So please, please, please take a look at all of the resources that are there because it's incredibly helpful. So yeah, this is a slide on how to get help. There are some, a link to some free resources. If you have questions, you can email some of us, the presenters, and then I also linked application for assistance here. So yeah, I believe that's about it for this presentation. And thank you so much.
Thank you, Ramia and Ritu. That was so much helpful information. We have a couple of questions. I think some were answered in the Q&A. We do have a question from Vivian. Would electrical be considered tenant or landlord responsibility? Electrical improvements.
So it kind of, again, will depend on the terms of the lease. So hopefully your lease addresses electrical, but from when I've reviewed leases, usually if the electrical is particular to your unit or like in your unit, then it's usually going to be the tenant's responsibility. If it's electrical that's impacting like many tenants, then, it's likely, and it's not just like your unit, then, it's likely that it could be the landlord's responsibility, but it's going to be in your lease if you have one. And if you don't have a lease, then we'd have to kind of figure out based on common law and, whatever arguments we can make as to why it should be the landlord's responsibility for the electrical. But usually if things are particular to your unit, it will often be the tenant's responsibility.
Thank you. I think another question that we have received a lot are around can the landlord increase rent during the lease term? If so,
Yeah, so it
how
will
much and when?
Yeah, so during the lease term, it depends on what the lease says, right? So often, if you have a multi-year lease, like a 3 to 5 year lease, the lease itself will say, the first year the rent's going to be X, and then the second year it's going to go up by 3%, and then the third year it's going to go by another 3%. So you have to look to the lease. But if your lease doesn't say anything like that, it just says the rent is, whatever, like 2,000 a month, and the term of the lease is 2 years, then during that term the landlord does have to keep it at 2,000. Once the term is over, and let's say you become month to month, the landlord unfortunately can increase the rent as much as they want because there's no commercial rent control in California. And in fact, there's a state law that prohibits any sort of commercial rent control. So yeah, during the lease term, they have to stick to the terms of the lease, whether that be, the rent's going to be the same for the couple years that you're under the lease, or if it's going to change during the lease term, it has to be in the lease itself.
Okay. Couple more questions. Do you assist landlords with their lease agreement?
No.
Okay, so you're focused on business tenants, not the
Yeah.
landlords. Okay.
And neither Public Counsel or Tzedek assist landlords. But we do have a model commercial lease agreement on our websites that I can link to that anybody can use, as their template for a lease, but we don't assist landlords.
And
Great.
just to add on that, we can also provide, if there are any landlords, a referral to the LA County Bar Association. They have attorneys that can work with landlords for a reduced fee. So we are happy to provide that resource too if people here are landlords and they need help with that.
Thank you, Nadia. Another question is, if you have a month-to-month lease, or it says no lease, are there any restrictions, timeframes that apply to rent increases?
So if you're a month to month tenant, or don't have a lease, so there's no, term or anything, like I said before, your rent can be increased as much as the landlord wants. Under SB 1103, the new law that Ramia just talked about, if you are a qualified commercial tenant and you let your landlord know that, they do have to give you extra notice of the rent increase, like a certain number of days. I believe it's 60. I forget now, but they have to follow the notice requirements. If you're not a qualified commercial tenant, because you have more employees than what a qualified commercial tenant would have, then you are at least entitled to 30 days notice. But other than giving you the notice, the landlord can increase the rent as much as they want.
Okay. We have a couple other questions that we have seen. One question about early termination and default. What penalties apply for breaking the lease?
Again, it's going to be in your lease itself. So there's going to be, if you have a written lease, there'll be a whole section on default, and what happens if the tenant breaks the lease. Usually what those leases say is that if you break the lease, there could be some immediate financial, penalty. Plus the landlord wants to hold you responsible, to pay rent. Sometimes the landlords will try to say, you owe me rent through the end of the lease. Like, let's say there's 3 more years left, you owe me rent for 3 years. But we often will argue that that's not reasonable, and that the landlord has a duty under the law to mitigate, which what that means is the landlord has a duty to make reasonable efforts to re-rent the place. And so they can charge you rent until they find a new tenant, which for some spaces obviously could take a long time, right? Because given this economic climate, there's a lot of vacant spaces. So yeah, the lease will tell you what the penalties are. If you have a lawyer, like from Public Counsel or Tzedek, it may be possible to negotiate with your landlord before you leave and break the lease, where in writing the landlord agrees to let you end your lease early and not have to pay anything for it. Um, but again, unless you have that in writing, I don't recommend, obviously you have to decide what you're going to do, but we've had clients who've just left, early and given back the keys. And then a year later, they're sued, for the back due rent until the lease ends. And so if you can help it, it's possible, if it's possible, it's best to get an agreement with your landlord before you leave that says, they're letting you break it early, they're not going to ever go after you for your whatever happened during your tenancy or for the remainder of the lease term. And we've had some success doing that, but it obviously doesn't work in every case. But sometimes we're able to get that.
Okay. I'm not seeing any more questions. We can end here. Maybe any final tips, I think, Ritu or Ramia, to offer the attendees on like how they can be protect their businesses. Some kind of easy takeaway.
Yeah, I mean, just recognizing that, and all of you know this, it's so hard to operate a small business these days, and there's a lot of potential legal challenges, but both Public Counsel and Tzedek are here to help you. Try not to wait till it's an emergency to seek legal help. Like if you have the time, try to get the help beforehand. And I'm also just flagging, and I can share this with Rosalind. We're going to be doing 2 trainings in December for small business owners. One is on how to stay compliant with state and federal disability laws, because we have a lot of small businesses that get sued by these serial plaintiffs for having stairs in front of their door, or having a doorway that's too narrow so somebody with a wheelchair can't get in, or having aisles that are too narrow. And it causes a huge problem, obviously, once you're sued like this. So we're trying to help people understand what the laws are to help minimize the potential of you being sued. But yeah, and then we're doing one on choosing a business entity for those of you that might be sole proprietors that want to, are interested in learning about whether it would make sense to create a business entity. So I'll share those flyers. But yeah, just, wanting to note again that we're here to help you. So please reach out.
Yes, and I just want to reiterate what Ritu said that, please try not to wait until it's an emergency. I know things can be tough, but it's easier for, everybody if you're able to come to us beforehand or with enough time. But I just want to say that I'm here, and the whole point of my work at Tzedek is to specifically help legacy businesses. So I am quite literally here for you all and here to support you. So please email me. I believe Rosalind will be sharing the presentation that also includes my email, but I can put it in the chat as well. So please don't be afraid to reach out to me. Tzedek Public Counsel, we are truly here to help you. So yeah.
Thanks so much to our wonderful speakers today. We've learned a lot, and as they said, they're here to help you. And we'll be sharing out the recording of this webinar as well as the slides, I think, and the contact information of the speakers, as well as the other additional clinics that Ritu just mentioned that are happening in December. So if you have time, we encourage you to check that out. Thank you so much. We are continuing our webinar series this month. I think we may have a slide of our upcoming dates and topic. I think we're going to show that. So December 9th, we will host a webinar on government contracting. And then on December 16th, we will tackle e-commerce and digital marketing. So we hope you've been finding these webinars helpful, and invite you to join us at the next one. Thanks again, everybody, and have a great day.